All right, let me share my screen. Can everybody see my screen?
Yes.
Oh, perfect. All right, Joe, it's all you.
All right. So thanks, Anya. Again, my name is Joe Kelly, and as Anya said, I work for FYI at the U.S. Department of Labor, where I work in the Labor Relations Office. And if you were able to attend the first session on this, we, we went over this topic, federal sector labor relations, from the angle of the. Anya, do you want to put it in full presentation mode? Great, thank you. So in the first session, I covered federal sector labor relations from the angle of the agency charged with administering the federal sector labor laws in the U.S. Code. And today I wanted to talk about the statute itself, the federal laws passed by Congress that that guide the federal sector labor relations process. So next slide, please. So here's a roadmap. We're going to talk about what is federal sector labor relations. We're going to talk about the Federal Service Labor Management Relations Statute. And then at the end, if there's time and interest, we can do some Q&A. Next slide, please. So what is federal sector labor relations? It's the system governing the labor management relations between agency management and employees under the framework of the Federal Service Labor Management Relations Statute. So I'm not sure what that exactly means. Next slide. So I think an easier way to think of it is it's federal sector labor relations is the process that gives federal employees the right to join a union, to engage in collective bargaining, and to participate in decisions affecting employment. I think that's a much simpler way to think of it. Next slide, please. So what is collective bargaining? So it's defined in the U.S. Code at 5 U.S.C. 7103 A12. And here's a huge run-on sentence that I don't find very helpful, but I wanted to put it up so you can take a gander at how the statute actually defines collective bargaining. Next slide, please. So then really what is collective bargaining? It's when agency management and a union negotiate in good faith over the working conditions that affect the agency's employees. It's a pretty simple take, and I think that is a good definition. Next slide, please. So the laws governing federal sector labor relations, the statute passed by Congress in 1979 is they passed it in 1978 and went into effect in 1979. It's the Federal Service Labor Management Relations Statute, also known as the FSLMRS, also known as the statute. I prefer to call it the statute because that way I don't get tongue-tied trying to call it its other names. And you can find it in the U.S. Code at 5 U.S.C. 7101 through 7135. Next slide, please. So what does the statute do? For most federal employees, it establishes the right to organize and participate in a union, to engage in collective bargaining, and to negotiate over working conditions. The statute itself can get kind of complicated and wordy, but at its fundamental, it's about these 3 points: the right to organize, the right to organize and participate, the right to engage in collective bargaining, and the right to negotiate over working conditions. Next slide, please. So in the statute, the Congress starts out explaining how it came to the decision to write and enact this statute. And the purpose of this statute is to prescribe certain rights and obligations of federal employees, to establish procedures designed to meet the special needs of government. So the purpose of the statute is to create sort of a new scheme of rights and responsibilities in the federal workplace regarding the federal workforce. So Congress also states that the provisions of the law should be interpreted in a manner consistent with effective and efficient government. So that's really what they're after. They, in their infinite wisdom, they decided that this was a good way to sort of move forward with effective and efficient government processes. Next slide, please. So Congress found that Congress is always looking out for the public interest, at least they're supposed to be. So in this case, Congress found that the public interest demands the highest standards of employee performance within the federal workforce. It demands the continued development of progressive work practices. That means continually improving processes and work practices to make things better over time, and to facilitate the efficient operation of the federal government. Next slide, please. So Congress also found at the beginning of the statute, or it states in the statute, that it found that the protection of employees' rights to organize, bargain collectively, and form their own unions benefits everyone. It's not just the people in the union. It's not just the union bosses. It's also the heads of the agency. It's also the public that receives services from the federal government, because this, the process of bargaining collectively and organizing, it keeps employees happy. And that just creates a better environment for everyone. It gives agency heads sort of a certainty in how things operate. When the labor movement came out of, in the 20th century, there was a lot of strife, a lot of bloody strife about the rights of workers and disputes between employees and employers. And Congress passed labor laws, both for the private sector and for the public sector, to sort of quell the unrest that had sort of taken root with workers who were exposed to all sorts of horrible working conditions in various industries. And in order to quell that unrest, Congress designed, legal schemes and gave employees rights and gave employers obligations to sort of, I'll say, calm everybody down. So Congress found that labor unions and collective bargaining in the civil service are in the public interest. Next slide, please. So Congress also found that allowing federal employees to organize safeguards the public interest, contributes to effective public business, or contributes to conducting effective public business, and encourages the settlement of disputes between employers and employees. Next slide, please. So who administers the statute? As we talked about in the first part of this series, the agency charged with administering the statute is the Federal Labor Relations Authority, also known as the FLRA, also known as the Authority. And the authority makes rules and regulations to enforce the statute passed by Congress. Next slide, please. So the first substantive points addressed in the statute are the conveyance of employee rights under 5 USC 7102. Next slide, please. So here, Congress gave employees new rights that did not exist under law until this statute was passed. And those rights are to join or assist a union, to not join and not assist a union, to be free from penalty or reprisal for joining a union or not joining a union. And individual employees have a right to act as a representative. So each federal employee who has the right to join a union has an individual right to act as a representative for the union as well. That's found in 5 USC 7102. So federal employees also have the right to present the views of the union to government officials. And I think that's huge because who among us can sit across the table from our boss and tell them what we really think, or even sit across the table from the owner of the company and tell the owner of the company what you really think. There were no protections against being terminated for expressing your views in the workplace, or telling your boss what you think of a work assignment. So this is actually a really big deal to give federal employees the right to present the views of the union to government officials. That doesn't mean they get to mouth off, right? But that means they get to sit down across the table and look their bosses in the eye and express the views of the union. Employees also have the right to engage in collective bargaining with respect to working conditions. And working conditions it's really just conditions at work. It could be everything from the type of desk you have to the temperature of the office, to the type of vehicle they provide you with to perform your work. Just conditions at work, and it covers a myriad of things. And employees have the right to select their own union representatives through the democratic process. Next slide. So the powers and duties of the FLRA under 5 USC 7105. Again, we went over this in pretty good detail in part 1, and so I just want to do a quick refresher here because the statute does lay out the powers and duties of the FLRA, and all the detail we went into are based on the processes and regulations that the FLRA itself developed in order to administer the statute. Next slide, please. So the FLRA determines appropriate bargaining units. And so you can just think of that as determining determining what positions should be in a union. One example is at the Department of Labor, we have labor investigators in the Office of Labor Management Services. And those labor investigators have a bargaining unit unto themselves. The only positions in that bargaining unit are labor investigator positions. And when they were forming their union, they decided that's how they wanted to structure it. And so they went to the FLRA, and the FLRA determined that their proposed bargaining unit of only labor investigators made sense. And so the FLRA determined that was an appropriate bargaining unit. The FLRA supervises bargaining unit elections. So this isn't electing the individual union officials. That's also done through the democratic secret ballot process. But this thing that I'm talking about right now is supervises the elections of the union itself. So when you choose the union, when the employees vote to choose the union they want to represent them. And the FLRA resolves disputes over collective bargaining. Next slide. Some more things that the FLRA does. They resolve unfair labor practice complaints. They decide appeals of labor arbitration awards, and arbitration awards come out of the grievance procedures that unions use, the federal sector unions use to decide disputes between employees and agencies. And then the FLRA acts to effectively administer the statute. And that's the piece that gives them the ability to promulgate regulations and make rules and design processes to make the statute work for federal employees. So next slide, please. So next we go to management's rights under 5 USC 7106. And these are the new rights that Congress bestowed on agency management with regard to labor relations. Next slide, please. So management rights are the rights given to agencies to act and make decisions to conduct the government's business. Obviously, in order to run the organization effectively, you're going to need authority to take actions and make decisions. And so this is what Congress was providing the agency with a specific set of rights in the collective bargaining process in the federal sector labor relations scheme, so that it can effectively conduct its business while also engaging with the union and fulfilling its responsibilities to collectively bargain. So next slide. So under management rights, management has the right to determine the mission of the agency's budget, the org chart, the number of employees, and any internal security practices. Those are absolute rights that are left completely to management. Those are not things the union gets to have a say in. The next slide, please. Now, subject to law and other authorities, and that's sort of a big caveat there. Management has the right to hire, assign work, and direct employees, has the right to suspend, fire, demote, and discipline employees, and it has the right to assign work, contract out, and make personnel decisions. And when I say contract out, what I mean is basically what FYI does. In my case, the Department of Labor contracts with FYI to provide labor relations personnel, and management has that right to decide, instead of hiring new federal employees for these openings we would prefer to go to a contractor and have the contractor provide us with personnel to fill those empty positions. So one interesting note here is all the talk about the elimination of telework. Management has the right to well, let me back up for a second. The Federal Labor Relations Authority has found that telework, when telework involves a management determination about assigning work and directing employees. They get to assign the work that their instruction to come back into the office is an assignment of work, and they also get to direct employees where they can perform that work. And so a lot of the disputes over the revocation of telework or the canceling of telework is whether management actually has the right to do that, because there is a telework statute, there are telework regulations. Each agency has its own telework rules and policies, and it's a big mess of spaghetti trying to untangle whether management can lawfully just revoke telework in the way that it was done. That was just a quick aside. Next slide, please. So management has the right to select employees for promotion from a list of properly ranked and certified candidates. Management has the right to take actions necessary to carry out agency business during emergencies. A great example of that is the COVID pandemic in March of 2020. I believe it was March 16th, 2020. They sent everybody home. They had technically they had a legal obligation to bargain with the union before they took an action like that affects the working conditions of people. But given the exigent circumstances of a pandemic, a deadly pandemic, there was no time to notify the union and to engage in bargaining before sending everybody home. It had to be done, and it had to be done immediately. And so that's the sort of action that management has the right to do under exigent circumstances. And as we said before, they have the right to assign work and contract out and make personnel decisions. Next slide, please. All right, so here are some things that management may choose to negotiate over with the union. They don't have to, but they can choose to. And this includes the numbers, types, and grades of employees, um, positions assigned to any work project or tour of duty. So what particular positions we'll be doing. Management doesn't have to negotiate that with the union, but it can choose to negotiate that with the union, and the technology, methods, and means of performing work. And so what that is like a particular software, piece of software that you're using, or whether you're using specialized equipment. Um, what kind of communications platforms do you use in the course of your work? Those are the technology, methods, and means of performing work, and the agencies can choose to negotiate over those with the union if it sees fit. Next slide, please. And here's the list of things that management shall negotiate over. Congress decided that it was that there were things that management had to negotiate over, and those are the procedures used in the exercise of any management right, and the appropriate arrangements for employees adversely affected by the exercise of management rights. So, recent example at the Department of Labor, we had new senior leadership come in with the new administration, and they're making some changes. They want to do some things differently. They have a different vision for the department than the previous administration. And so one action they took is to require employees not to just badge in as they've always done. You come in the morning, you go to the security entrance, and you tap your badge, your PIV card on the little badge reader, and it beeps and lets you in. So people at the Department of Labor have always been doing that, but now new leadership wants people to badge out as well, something that's never been done before. It's now it doesn't. If you're already badging in, then what's the big deal with badging out? It's exactly the same act by the person badging out. So what is there to negotiate over? Well, first of all, this is a management right that involves internal security practice. So that's an absolute management right that the union does not have to, or the union does not have a right to involve itself in. Management can make that decision to require everybody to badge out when they leave the office. And their rationale is they want to have better control over who's in the building, a better idea of who's in the building, just for building security and for emergency response. So management has the absolute right to require people to badge out, but there can be an impact on the bargaining unit, on the union, on the employees when they're badging out. It might not seem like there would be much of an impact because, like I said, it's exactly the same action of swiping your badge, but there might be issues like there aren't enough readers to accommodate the people who are coming in and going out of the building at the same time. So you might get a road, like a traffic jam of people trying to exit because there aren't enough readers. Or you might have the readers that were placed for entering the building, and now they're not really as accessible if you're trying to leave the building. Maybe employees can't leave out the same exits that they used to leave because there's no badge reader at that exit. So little details like that can affect employees, and those are the types of arrangements, or those are the types of things that the union can negotiate over, that management shall negotiate over, is the impact that their decisions have on employees, even if the decisions they make are fully within their rights to do so, and the union has no input. They still have to bargain over the impact that their decisions have on employees. Next slide, please. Okay, so here the statute talks about the exclusive recognition of labor unions, or just I call it choosing your union, and that's in 5 U.S.C. 7111. Next slide, please. So a federal agency shall recognize a union as the exclusive representative of employees if a majority of employees who cast ballots select the union. So this is not a majority of employees. This is a majority of employees who cast ballots. And there can be a huge difference in outcomes. You could have 1,000 people who are eligible to cast a ballot for a union, but some people might not be interested. They might not be aware of the election, and only 20 people show up to vote. And unions have a saying: "Those who show up decide," and that's exactly the case here. If only 20 people show up to vote for the union, the will of those 20 people is going to be affected by their choices. Next slide, please. All right, so the process for selecting a union is somebody files a petition claiming that at least 30% of employees want the union to represent them. And that 30% threshold, that's just for filing the petition. That's not, you need to have a majority of employees vote to make the union the exclusive representative. But to get the petition process going, you need to claim that 30% of employees want the union to represent them. And then the FLRA will investigate that petition and that claim. Next slide, please. So what's the process for deselecting a union? Because just like you can hold an election to select a union, employees can also hold an election to deselect a union if they're unhappy with their exclusive representative, or they just don't want the union representing them anymore for various reasons. They can petition the FLRA to do that. And to deselect a union, somebody files a petition claiming that 30% of employees do not want their current union to represent them anymore. Next slide, please. So FLRA takes that petition and will investigate it, and we'll hold a hearing. We'll receive testimony and evidence about sort of whether or not 30% of people in FLRA's judgment really do want the union's representation, or to deselect the union, depending on what type of petition we're talking about. If FLRA finds after the hearing that there's a legitimate question of representation, if they think that it very well might be the case that a majority of people are going to make a certain choice, then it will call for a secret ballot election. More than one union can be on a ballot, so that would give employees the opportunity to choose the union that they would most prefer to represent them. And the union that gets a majority of votes is certified. If no union gets a majority of votes in the secret ballot election, then it goes to a runoff that is also overseen by the FLRA. Next slide, please. So the FLRA is the agency is the body that certifies the union or decertifies the union after the election. But it can refuse to certify the union if it determines that the union is subject to corrupt influences or influences opposed to democratic principles. Next slide, please. Okay, so excuse me. So bargaining unit determinations is under 5 USC 7112. Next slide, please. So a bargaining unit determination is the process used by the authority to determine which positions should be included in a bargaining unit. I talked about the example of the labor investigators at DOL were an appropriate unit. Excuse me. Next slide, please. So the FLRA determines the appropriateness of any bargaining unit. And its rationale is it wants to ensure employees, well, this is Congress's rationale, that Congress wants employees to have the fullest freedom in exercising their collective bargaining rights, and that in Congress's judgment, having an appropriate bargaining unit ensures that full freedom for employees. And an appropriate union should be established on the basis of a clear and identifiable community of interest, like job functions, It could be a geographic region, as long as the clear and identifiable community interest that has some common sense weight behind it. Next slide, please. So not everybody gets to be in the bargaining unit. Under federal law, bargaining units must exclude all managers, all supervisors of agencies, all confidential employees. And a confidential employee is somebody who works in personnel with confidential information, making decisions that affect employees. Employees engaged in personnel work other than in a clerical capacity. So, for instance, I do personnel work other than in a clerical capacity. So I'm not eligible under federal law to join a bargaining unit of any kind. Also excluded are employees who administer the statute. Again, I fall into that category because I work in labor relations. Next slide, please. So more positions that must be excluded are anyone engaged in intelligence, counterintelligence, investigative, or national security work. So, for example, CIA spies and FBI counterintelligence operatives, those sorts of folks, they don't get to join a union. And the rationale for that is that they work with very important, very sensitive, and secret information, and they it's against the public interest to allow them to bargain collectively and share the knowledge that they have with the union. So they're excluded from the collective bargaining process. Employees primarily engaged in investigations or audit functions. So you can think of the inspector generals or inspectors general. Those folks who investigate and audit functions related to individuals. Those folks are excluded from being in a union, and also labor relations employees are excluded. And once again, I fall into that category. So I meet three of the exclusions. So I will never, ever. And next slide, please. So now we will move to representational rights and duties under 5 USC 7114. Next slide, please. So these are the rights that the union has received from Congress through this statute. We talked about individual employees and their rights conveyed by the statute, and we talked about management's rights. And here we're talking about the union's right as an institution, as an organization. They have the right to act on behalf of all employees in the bargaining unit and to negotiate collective bargaining agreements covering all employees in the bargaining unit. In a collective bargaining agreement, most people, when they say collective bargaining agreement, they're referring to the term agreement, or the master labor agreement, it's sometimes called. But a collective bargaining agreement can be any agreement made between the union and management. It can be a memorandum of understanding. It doesn't necessarily have to be, what we think of when we think of a labor contract. Next slide, please. So the union is responsible for representing the interests of all employees in the bargaining unit. It can't pick and choose. It has a duty to each member of the bargaining unit, each employee in the bargaining unit. It must represent their interests. And the union cannot discriminate against non-members in the bargaining unit. And you might pause and you might say, well, wait a second, how can you be a non-member of the union but also be in the union bargaining unit? And so these are two distinct things. You've got the bargaining unit employees, and then you have membership in the union. You can be in the bargaining unit and then exercise the right that we talked about a little while ago to not join or not assist the union. So in that case, you're still in the bargaining unit, and the union is still responsible to represent your interests in the workplace, but you choose not to be a dues-paying member of the union. You And so you're not a union representative. You don't get involved in internal union business. You don't go to union meetings. You just stay out of the union, but you're still in the bargaining unit, and the union still has to represent you. Next slide, please. So the union gets the opportunity to be represented at, so the union gets the opportunity to attend through a representative any formal discussion between an agency boss and an employee concerning a grievance or personnel policy, personnel practice, or discussion of conditions of employment. So the union has had its own separate right to be at that discussion. Next slide, please. So union also gets the opportunity to be represented by a union rep at an interview of a BUE in connection with an investigation if the employee reasonably believes that discipline could be the result of the meeting. For instance, if the boss is asking you questions about some misconduct that they believe you might have engaged in, and if you answer your boss's questions, then your boss is going to realize you did engage in that misconduct and you're going to get disciplined. So if you're facing that kind of thing, then an employee has the right to invoke union representation at that meeting with their boss, and the union gets to sit in and represent that employee, just like an attorney would represent somebody during questioning by police. Next slide, please. Oh, and I'll just say about that last slide, you don't have to go back, Anya, but that last slide, we refer to that right to invoke union representation when your boss calls a meeting where you think discipline might result. We call those Weingarten meetings, and that phrase is used a lot. It comes out of the case law that found that employees do in fact have the right to union representation during a meeting in which discipline might be the result. Okay, so this Congress said that the agency and the union shall meet and negotiate in good faith to arrive at a collective bargaining agreement. So those are both the agency and the union have both the right and the obligation to meet and negotiate in good faith. So it's a two-way street. Next slide, please. So employees also have the right to be represented by their choice of representatives. So even though the union is considered to be the exclusive representative of bargaining employees, individual employees still have the right to hire an attorney of their choosing or select some other representative to represent them in any grievance or appeal action with management. Next slide, please. So an agency has a duty to bargain in good faith with the union. And what the duty to bargain in good faith means is to approach negotiations with sincere resolve to reach agreement. So you really need to be trying. You need to be invested in the process, and you need to try to reach agreement. You need to be prepared to discuss and negotiate the matter at hand. The agency can't just send some mid-level manager without authority to actually agree to reach an agreement about the issue at hand. The person that management sends needs to be to have the authorization to bind management in an agreement. And the agency also has a duty to meet at reasonable times and convenient places as frequently as necessary and to avoid unnecessary delays. So no dragging your feet, agency. Bargaining in good faith requires meeting at reasonable times and getting it done as quickly as reasonably possible. Next slide, please. So Congress also gave unions the right to request information from management. You can think of, if you're familiar with the Freedom of Information Act or FOIA, this is kind of akin to that. There are some differences, but it's a helpful analogy, I think. So upon request by a union, an agency must provide the union with information that's normally maintained by the agency, reasonably available, and necessary for a full discussion within the scope of collective bargaining, and which does not constitute advice, counsel, or training related to collective bargaining. So, and you've got to meet each of those three elements for the information to be disclosable. For the agency to have the obligation to disclose that information, it's got to meet all three of those points. I recently had an information request where the union was asking for all of the legal authority for all of the charges contained in the DOL table of penalties, which is a little matrix of, for discipline purposes, you have various offenses that employees may commit, and then, guidance on what kind of penalty is appropriate for those offenses. And the union wanted all the legal authority behind those offenses and the guidance on the penalties. And I got to say no to that request because DOL doesn't maintain all the legal authority behind the misconduct charges. Those are decided through, federal regulations, MSPB cases, lawsuits, all sorts of legal authorities outside of the Department of Labor. And so the information that they were looking for was not information that was created or maintained by the Department of Labor. And their request basically was for me to do their homework for them because they were trying to prepare for a labor arbitration. And I'm not doing their homework for them. If the department did maintain that information and create it in the normal course of business, that would have been different. But the authority for all those misconduct charges are all over the place out in the legal sphere, and so management didn't have to comply with that request. Next slide, please. So another joint right and obligation is for both the union and the agency to execute and implement an agreement without delay. So, for example, if the parties engage in collective bargaining and they reach agreement, and they both have an obligation to execute that agreement and implement that agreement, and no one's allowed to drag their feet. And I was thinking about sharing an anecdote, but I don't think I can. I don't think it's interesting enough. So I'll move on. So any agreement that's reached between the union and the agency is subject to agency head approval. And what that means is the Secretary of Labor gets to review any agreement that management entered into with the union. And if the agency head believes that the agreement infringes on a management right or doesn't comply with existing law, then the agency head can reject it, and the agreement is voided by the agency head. And the agency head review must be completed within 30 days. If not, the agreement automatically takes effect on the 31st day. Next slide, please. So allotments to representatives. Congress gave the unions a process to collect dues through federal agencies where their bargaining unit employees and members work. You can find that 5 U.S.C. 7115, also known as union dues. Next slide, please. And this is a pretty simple process. If an employee provides a written authorization to an agency to deduct the union dues from the employee's paycheck, the agency will make the deduction, remit the funds to the union, and not charge the union or the employee anything for providing that service. Next slide, please. So unfair labor practices, ULPs. We went over these in depth in the first course, but we'll breeze over them again. Next slide, please. So an unfair labor practice is conduct by an agency or a union that violates rights that are protected by this particular statute. Next slide, please. So some examples. So unfair labor practices can be committed by the agency or the union. It's a two-way street. And a ULP by an agency, some examples of that are, discriminating against an employee due to that employee's union activity, refusing to negotiate in good faith with the union, turning employees off to union membership, discouraging them with veiled threats, for instance, or threatening their next performance evaluation will be poor if they get involved with the union. That's an unfair labor practice to engage in that kind of conduct. Make changes to employees' working conditions without notifying the union. Whenever you're changing working conditions, even if you're exercising a management right that management has the absolute right to do, you still have to notify the union and let them know that change is coming. It's a ULP to fail to cooperate with impasse procedures by the FLRA. Next slide, please. So, like I said, ULPs can also be committed by a union. And some examples of this are discriminating against an employee in union matters based on that employee's protected class, race, sex, sexual orientation, national origin, that sort of thing. Refusing to negotiate in good faith with the agency, just as the agency has a duty to negotiate in good faith, the union has a corresponding duty to negotiate in good faith. Refusing to cooperate in impasse procedures at the FLRA is an unfair labor practice if done by a union, and to go on strike is an unfair labor practice in the federal sector because federal employees are not allowed to strike under law. It's unlawful to strike. And you can find more examples of ULPs in the statute at 5 USC 7116. Next slide, please. Standards of conduct. So Congress wrote in some standards for the unions that they need to meet in order to be recognized as labor organizations. Next slide, please. And basically, it comes down to two. Unions cannot be corrupt, and unions cannot be made up of communists. And the no communist one is a little strange, but in the historical context, it makes sense. Because in the late 70s, the Cold War was with the Soviet Union was very intense, and it was a big subject of public discussion and public awareness. And Congress, in its infinite wisdom, decided that communists could not join the union. And I mean, it turns out that's a huge First Amendment violation, and there's been case law that the union can't exclude communists from its ranks. Communism, it's a political ideology that falls under free speech and free association. And so even though the law is still on the books, it's been overturned through case law, and people of all sorts of political persuasions can join the union. Next slide, please. So grievance procedures. These are the procedures used to settle the disputes between management and employees. And this is one of the big reasons Congress enacted the statute was to provide sort of more certainty in resolving disputes between employees and management. Next slide, please. So what's a grievance? A grievance is any complaint by a union or an employee concerning any matter of employment. It's very broad. You can just think of it as a complaint. And it's also any complaint by a union, employee, or agency concerning the interpretation or breach or the application of a collective bargaining agreement. So you might have an issue in the workplace, like maybe the thermostat is too low, and you're going to file a grievance because you want them to turn the heat up because you can't work when you're cold. or a grievance. The union can also file a grievance over management's interpretation of a collective bargaining agreement. Next slide, please. So the statute says that any collective bargaining agreement or CBA shall contain a procedure for resolving grievance disputes. The procedures shall be fair and simple, provide for expeditious processing, and provide for binding arbitration if not resolved. And I like that fair and simple point a lot. You know, if you sue somebody, if you sue your boss in court, you need to hire a lawyer. The court processes are complicated. The law is complicated. Um, the law has its own language that non-lawyers probably don't know, and it's super complicated and super stressful, and you need to hire really expensive professionals to represent you. But in a grievance, these processes are designed to be fair and simple so that disputes can get resolved. That's the bottom line. Next slide, please. So some subjects are excluded from the grievance in the federal statute. Things like complaints about retirement benefits, life insurance, or health insurance. You can't file a grievance over a suspension or removal if those actions are taken in the interest of national security. First example that comes to mind might be like a CIA operative who engaged in some misconduct while on a mission. I just made that up. I don't have any expertise in that area, and other exclusions can be negotiated by the parties, and they often are. Next slide, please. So arbitration decisions, so arbitration appeals are also addressed by Congress in the statute. Next slide, please. So arbitration is the dispute resolution process where a third party comes in and acts as a judge to resolve a dispute between an employee and management. And the decision made by that third party is binding on the parties, just like a judge's decision is binding on the parties in a lawsuit. And the arbitration process is outlined in the collective bargaining agreement between management and the union. Next slide, please. So how does a party appeal an arbitration award? Either party to arbitration can file an appeal with FLRA. Parties have 30 days to file a petition for review, but the grounds for FLRA review are limited. Basically, there are two grounds. One is that the arbitrator's award violates federal law somehow, or two, it violates, it's contrary to the parties' collective bargaining agreement. Next slide, please. And that will wrap it up. And I was just about to wrap it up, so that's good because I see we only have 5 minutes to the top of the hour. So if there are any questions, I will do my best to answer them.
Hello, Joe. Good afternoon. This is Brenda Edmond. I am currently with FYI as a classification specialist. And so, but I am a prior author of many policies at different agencies, okay? And especially Department of Education, HUD, FEMA, and the United States Citizenship and Immigration Services. I've also defended those policies in arbitration. And so when you are speaking to all of the ULPs and the opportunity to file ULPs, either on behalf of the, the union, on behalf of the employee, et cetera. So, given consideration to all of the stuff that's going on in the last, 10 so days, right? And I'm most appreciative of seeing that the FLRA has gotten involved in some of this activity. There's been a lot of, my concern especially, and I'm not trying to make this political or anything like that. I'm certainly making this, a concern with the bargaining agreements and the language in those bargaining agreements, especially when it involves personnel changes, right? Or the idea of coercing or encouraging, if you will, individuals to, take a personnel change, and then doing so with only a certain period of notice, when we already know the notice to make those changes first has to be bargained through at least a 30-day notification, and some of the bargaining agreements, right?
Yeah.
From HR, to the union. And so across the board, you've got lots of agencies that are, that this all affects. So given that you are a contractor with FYI to the Department of Labor, what is labor doing? I just kind of want to get an insight of what is labor doing on behalf, of all the federal employees that are, subjected to this coercion. And then there not be a notification, for those individuals to, or at least the HR offices within the agencies being able to make that notification and protecting, all employees, if you will. It just kind of, curious of what your knowledge or insight of that is.
Yeah, so the Department of Labor doesn't have any role in federal sector labor relations at other agencies. DOL regulates, one of the functions of DOL is to regulate private unions in some ways, but DOL doesn't really get involved in what other agencies are doing with respect to those other agencies' unions. So they're not really, so they don't have a role sort of government wide.
Okay.
That would be OPM, I guess, would be involved. The FLRA is going to be playing a big part. I haven't seen a ton of disputes roll in, or a ton of grievances roll in since the new administration came in.
Yeah.
But I guess that's TBD. I guess we'll wait and see. The senior leadership at the Department of Labor, who only has control over the Department of Labor employees and how it addresses notification issues, they're moving forward like you would probably expect based on what we know of the folks who are in charge of things now.
Okay.
They have less of an they're less interested in what the union thinks about what goes on. They're more interested in pursuing their agenda and doing the things they want to do, and they have a totally different approach than the prior administration.
Yeah, unfortunately. But thank you for that. And by the way, thank you for this session. I thoroughly enjoyed it.
Oh, I appreciate that. Thank you.
Yeah, you're welcome.
And we're right at the top of the hour, and I don't see any other questions. I'm happy to answer if there are any others. Oh, I see in the chat. Let's see. Oh, let's see. They file and resolve ULPs. Correct. So Erica asked, what about the agreements with the unions? Can they just ignore it? If you're still on, Erica, can you let me know exactly what you're asking? You probably asked that when I was speaking about something specific, and I'm not sure what I was talking about when you posted that to the chat.
Oh, yeah, it's on the line of Brenda's question. It's just the fact that some of the unions had negotiated and had an agreement about the telework policy, and then OPM stated that the supervisors managers can ignore those agreements. And I was just wondering, can they do that? Is that legal if they negotiated that with the unions?
No. If they negotiated that with the unions, and in the collective bargaining agreement gives employees clear rights to telework, an executive order is not enough to overturn employees' rights to telework under that agreement. The FLRA has there's a statute administered by the FLRA that says that it's an unfair labor practice to implement a regulation that directly conflicts with an existing collective bargaining agreement that was in effect at the time the regulation was passed. And the president's executive order the FLRA has found president's executive orders to be akin to regulations. So because there are collective bargaining agreements with rights to telework already in effect, as a legal matter, the president cannot overturn that just by issuing an executive order. He can hire people to tell them to just like steamroll it and ignore it, and let them file grievances and let them sue. And I think we're seeing that approach being taken. But as a legal matter, the management can't just rip up a collective bargaining agreement based on an executive order. If Congress were to pass a statute removing telework, then telework's done. Because a congressional statute trumps everything else. Pardon the word Trump there. But an executive order on its own can't overturn telework rights in a collective bargaining agreement.
Got it. Thank you.
Mhm.
Joe, Keisha had a question in the chat. How does DOL's enforcement of labor laws apply to probationary employees for all agencies?
So DOL doesn't deal with labor laws in the federal sector. DOL regulates private unions, but not federal sector unions. So the Department of Labor doesn't have any reach into the labor laws as they're applied to other agencies. Probationary employees, generally speaking, probationary employees have rights under the labor law. Probationary employees can join and assist the union. They can act as union representatives. They can file grievances. Their rights are limited in many respects, but they still have these collective bargaining rights that we talked about today. Those still apply to probationary employees, and that's true government-wide. Any other questions? All right. Well, hearing none, I will turn it back over to Anya.
Thank you so much, Joe, for the informative session. And once again, and thank you everybody who joined us today. And I look forward to the final session.
Yeah, part 3.
Part 3. Appreciate it. Thank you, everybody.
Yep.
The
Thanks,
session
everyone.
will be posted on my FYI. Have a great rest of your day.
Yeah. Thanks, Anya. Thanks, everyone.
Thank you so much.
Bye-bye.
All right. Bye-bye.